Wala ba ditong taga-BGC? Para sabay na lang kami.
Sino pending ko last week? Mr. Saka. Okay, mag-attendance muna tayo kasi pag nalalas pa sa pila. Can we use mood board every Friday? Sige. Sige. If possible. Tapos meron ba tayong kasabay ng class kapag Friday? Meron tayo here sa room 3. Tapos mo sa blue bed. Bread and bread. If I call your name and you haven't recited last week, then no. Mr. Macoco. Mr. Corbillon. Mr. Alvin. Ondoy class. So, ayun, better luck next time. May nadaanan ako, nung law student ako, pinag-prepare namin na masira yung kalsada between Las Piñas, papuntang UP Manila. Kasi yung prof ko is, if you know Attorney Lartizabal, succession professor siya, siya yung kapwa ng board nila that time. And tinatawag niya kami lahat ng mga bobo. Like, no matter how good you are, you're part of the flock, the bobo flock. So, there was one instance na sinabihan niya kami na, okay, class, dahil mga bobo kami lahat, mamaya at the end of this meeting, pipili ako ng leader ng mga bobo. So, she really mentioned that. So, parang, siya yung type of professor na papasok pa lang kami sa klase, nasusuka na talaga kami literal. May mga kaklase ako nagsusuka sa klase. I know there are professors like that here, but I don't want to be identified with them. So, as much as possible, I try to make the class time or easier to understand. Mahirap lang talaga yung subject, pero kung nagkita tayo sa gender, mas masaya itong klase na to. Kaya lang kasi nasa Corpo ako ngayong semester. Next time na lang kapag nag-gender ako ulit. Or other subjects na hindi major. So, ayun lang. Let's start, Mr. Orbigoso. Kasi, it's a good thing na nag-stop lang tayo last meeting. Kasi pagod na ako, pagod na kayo, pagod na tayong lahat. Okay. The question is, in the determination of corporate nationality of entities engaged in nationalized or partly nationalized activities, first, can you give us example of nationalized or partly nationalized activities? I'll give you a clue. Constitution.
Yeah.
Yeah.
If I recall correctly, the Constitution provides that public utilities corporations must at least have 60% Filipino owned. So
For public utilities, 60%.
at least 60% Filipino owned as to the common
So, do we call that nationalized or partly nationalized?
partly nationalized.
Okay, can you give us an example of a nationalized that it must be owned 100% by Filipinos?
Mass media.
Mass media, okay. So, next question. So for in the determination of corporate nationality of these entities, can you distinguish the application of control test versus grandfathering?
So control test is the primary test or the initial test which determines the nationality of a corporation, whereby the nationality is determined according to the outstanding capital stock. If it is at least 6%, then it is taken as a Filipino corporation or a domestic corporation. While the grandfather test, this test applies if there is doubt, still doubt after implementing the control test. So in this test, the nationality of the corporation is determined not based on the place of the corporation, but rather based on the nationality of each of its stockholders.
Alright.
Thank you, Father.
Next, Mr. Bago. Mr. Orbigoso mentioned particularly about doubt. Diba? Yung transition between control test and the grandfather rule. When there's doubt, you go grandfather rule. So, can you further explain what is this doubt?
In terms of doubt, the application of the grandfather rule is being applied because, or should I say, it arises when there is a doubt in the nationality of the controlling stockholders within the multiple layers of a corporation. And
Within
that's
the
when the
multiple layers.
layers.
So, which one is it? The ownership or the control?
I mean, the ownership.
Just the ownership.
Ownership and control of the
Okay,
corporation.
again. What is this doubt that we are talking about? I-incorporate mo lang yung control and ownership. Sagot mo nga. Wait lang. Class, can you move para one seat apart? Pwede kayong magturo ng seats. Kahit mag-merge na kayo sa seat. Just so
This doubt arises when arises or not arises. Sorry. In the grandfather rule, when there is doubt, this test traces the control and beneficial ownership of the corporation.
okay, so we mentioned about control and beneficial ownership. So does that mean that if I have control, I don't necessarily have the beneficial ownership?
Yes, certainly.
Like for example, a corporation owns dalawa yung example, corporation ABC, and then ABC, 60% owned by DEF Corporation, which is, and then siguro mga 30% by Filipino A, ayun, yung letter is 20% Filipino Y. Okay. And then, wait, saan ako sa example? We're talking about beneficial ownership, right? And then here, for example, this is 80% owned by Filipino X. And then 20% owned by foreign. Saan na tayo? W? Okay. So, example like that. So, how do we distinguish control versus beneficial ownership?
In control, you are entitled to vote. And in beneficial ownership, that is more like, say for you own the stocks, and at the same time you can, like, let's simply say that in a full beneficial ownership you can you are entitled to vote, or you have all the powers of a controlling stockholder. Meanwhile, in a control, you only have to control that there are limitations into what you can perform inside the corporation.
I think you missed the back. Okay. So let's just answer that question quickly. So beneficial ownership, it doesn't pertain to any kinds of stock. Okay? So, di ba meron tayong voting and non-voting? When it comes to talking about nationality and all, what matters usually, mainly, are the voting stocks. Kasi, yun yung may power, may capacity siya to decide. And usually, ang mapapansin niyo sa revised corporation code and the constitution, it usually limits the access of foreign nationals to this control of corporations, especially dun sa mga industries na ang laki ng impact sa natural resources, sa influence how people think. That's why kanina, di ba, it was mentioned, mass media must be 100% owned by Filipino corporations. Kasi ang laki ng influence doon to how people think, how people decide what news are given to the people. So, and then, asan ako? So we distinguish voting and non-voting stock. Sa beneficial ownership, it doesn't matter kung anong stock yung meron ka. What beneficial ownership means na example, corporation DEF, sa corporation DEF, 60%, di ba? And then, example si Filipino X, 80% siya daan. So, sa buong corporation ABC, makukompute mo, I'm not good at math class, pero ang makukompute mo dyan na si PhilX, 80% to 60%, yung control niya sa ABC. Kumbaga, nagbe-benefit siya from the stocks owned by something like that. That's beneficial ownership. Can you get the point, class? Whereas control is usually stick with the vote. How you influence the corporation, how you decide, up to what extent can you decide sa corporation. Kasi we will discuss later on yung powers na naka-attach sa different kinds of stocks that you own. So, yun muna, para hindi ko kayo magulo, throughout this class, you will learn kung ano yung pinagkaiba-iba niya. And hopefully, pag nag-recap tayo ng FICO before the final exam, mas gets nyo na yung latag ng corporation code. Okay? I will not blame you for not getting it agad. Kasi kahit ako hindi dito agad-agad. So, I would understand, but slowly, try to understand, try to absorb everything that you can para before finals, pag nag-usap tayo ulit ng recap, nakakasunod na kayo ng mas maayos. Okay? Next. Mr. Dagota. Mr. Dagota, can you describe to us what is the alter ego doctrine as a ground for tracing the corporate veil?
The alter ego doctrine provides that the corporate veiling is if it is found that the corporation is used as a conduit or as an instrumentality of the entity.
Of another person.
Another person.
Another person or another entity. Okay, I'll give you a tip class. For this class, for corporation law, use the term entity na lang para mas madali. Kasi it can be a partnership, it can be an OPC, a corporation, or a person. So, just for the sake of, alam mo yun, madali nyo makumpose yung answers ninyo. If you're not sure what kind of entity is that, just use entity. Just for the purpose of this class. Okay, can you still remember the elements of alter ego doctrine? It was discussed in one case. I remember that.
The elements of alter ego doctrine. First is control.
Okay.
Second is fraud. Third is harm.
Third is harm. Okay. Explain.
Control, it pertains to the control of the person or the entity over the corporation.
So, do you mean stock control? Just the stock control?
Control and beneficial ownership.
Control and beneficial ownership. Meaning, do you have to decide on all the matters as well?
Yes.
Such as? Okay, so if you have control, for control, it's not just mere stock control, but also control as to how the business will be run. the business decisions, whether we will increase the capital stock, whether we will buy, we will invest in another corporation, or we will invest in this particular business, or we will engage with partnership with another corporation, or we will use the services of another corporation. It's not just, para siyang puppet. Example is, si Corporation ABC, kunwari, isa siyang bake shop. And then, nagpa-plan siya, and then si DEF ay, example, bakery equipment business, si DEF Corporation. So, dahil si DEF Corporation, bakery equipment yung main business niya, ang gagawin niya, ibibenta niya ng ibibenta yung mga gamit niya. And then, since siya yung malaki yung vote kay ABC, kapag si ABC magde-decide sino ang gagawin niyang supplier, inuwagan niya yung sarili niya. Parang gano'n, pero hindi, I mean, it's just about deciding. Doon muna tayo sa decision portal. And that's basically how, the domination is, since ikaw yung may pinakamalaking amount of vote in total, malaki yung influence mo as to how the decision will turn out. And para siyang batas militar, technically, batas militar siya, ikaw lagi yung masusunod on whatever you want to do. Next, control and
The next element is fraud.
fraud.
So, in fraud, the control or the complete dominance of the person or the corporation is used to perpetrate fraud.
To perpetrate fraud. And lastly,
Lastly, harm. So, the exercise of control and the use of fraud should cause injury to another person or entity.
it must cause, the control must have proximate cause.
Proximate.
Cause. Hindi pwedeng nadaanan ko lang. Nag-civil code na kayo, di ba? Ano ang tawag ko? You must be the proximate cause, not just, alam mo yun, yung accidental lang na bagay. This one, you must be the proximate cause. Okay, thank you, Mr. Lago. Next. Miss Leo Florito. Hala, parang ang tawag yung mga nandito sa upuan. Okay, next. Explain the definition of capital as established in the Novoa versus Tevez and reaffirmed in Roy versus Service.
In the case of the whole resistance, the capital was defined there as it is not based on the constitution. It is not on the common shares. Capitals are not from the common shares.
Not the common shares. Okay, sige, let's move on to another question. How about, what is the general rule? Can officers be held liable for, together with the corporation in case the corporation is held liable? Am I making sense? Okay, so what's the general rule?
No, they are separate.
They are,
They are separate.
they are separate. That's the general rule.
Yes.
Okay, what is the exemption?
The exemption is that they can be only liable if there is fraud.
There is fraud. In section 30 of the revised corporation code, there was a particular enumeration as to when can you hold an officer personally liable for corporate acts. Can you give me some that you remember? I told you guys, we will also cover the revised corporation code as well, the law itself. book. Nandito siya sa likod. May revised corporation code sa likod. Hindi ko alam kung nakita niyo ba. It starts on page 895. Yeah, marami na. Meron ding basic securities dyan sa loob. That's why, sorry, wala yata. Pero there's a matrix as to the changes from page 982. If you turn your book on page 982, there is a comparative matrix ng changes ng old and new. So, if in case you're interested into checking ano yung mga nagbago, it's here. And the RCC is also here. You don't have to print another copy anymore. It's all here. That's why I picked that book. Okay, kahit wala sa revised corporation code, give me an example of an instance where the officer was held solidarily liable with the corporation for a corporate act. Something that really is, there are a lot of stuff there. A lot of cases. How about the ABS-CBN case? Have you read the ABS-CBN case? Okay, while waiting for Miss Newton to pass, if you, right now, if you have a copy of the revised corporation code, stick to it. Add notes, add markings if you want. You can use a separate revised corporation code copy, different than what's in the book, just to preserve your notes. Kasi believe me class, pagdating nyo ng 4th year, ang pinakamagandang balikan is something na nakakandaan mo. Nung binabasa ko na ulit yung notes ko pagdating ko ng 4th year and then the bar, during bar review, mas comfortable ako na yung gamit ko. Kasi mahilig ako magbasa ng total. That's what I do before the bar exam itself. Kasi pag naubusan ka na ng pangsagot, hindi ka magkakamali kung galing sa law itself yung sagot mo. And ang ginagamit ko copy ng law is yung ginamit ko din sa total or yung ginamit ko ng law school. Kasi particular ako, mas natatandaan ko yung mga hinighlight ko, mga binilugan ko, mga pinagdodrawingan ko ng arrow sa gilid, ganyan. It might also help you. So, if you have a copy of the RCC or the law itself, just stick to it.
Okay, at the previous event po, with another company, and in this event po, there are employees there that was,
Terminated.
yes, terminated, and then, those, employees sued, violent actions po, to the petitioners po.
Okay, I'll make your life easier. So, there was, di ba sa ABS-CBN, meron silang isang employee there who established another corporation. And that corporation, doon nabuo yung yung nagsusupply sa kanila ng services. And then, that person resigned again from that corporation, tayo ulit siya ng another corporation. And then, nung nag-tayo siya ng another corporation, lahat ng hinire ng services, nung unang company na tinayo niya, nire-hire niya karamihan except for the two. Hindi niya nire-hire. And then, nagdemanda sila for illegal dismissal, that the other corporation is just a conduit, an instrumentality to commit fraud. So, first question is, did the Supreme Court held that corporation as a mere did the Supreme Court held that the corporate veil must be pierced in that case?
in this case po, the Supreme Court ruled that
this case, the doctrine of piercing the veil of corporate fiction was discussed. There are three basic areas. Defeat public convenience, fraud, alter ego, and it was held here that this is the case of alter ego, where you can apply the alter ego doctrine, and they pierced the corporate veil. They held the officers liable for together with the corporation. And this is a classic example as to when corporations, when we can pierce the corporate veil. You can see the mix-up of cases there. May mga cases dyan na hindi nag-pierce. May mga cases na nag-pierce. May maraming cases na hindi hinold liable yung officers. May mga cases na hinold liable yung officers. I want to show you class paano nagde-decide this is the Supreme Court when it comes to piercing. Kaya pinaghalo-halo ko sila there para makita niyo different instances. And then for section 30, please at least mark them in your copies. That will probably definitely be part of your exam. Next. Last one is Mr. Alvin. Absent. It's his second time to be absent already.
Late po siya last online class.
Ang mga late siya. Pero natawag ko ba siya last time?
Yes po.
Ah, right. Oo, mag-message siya. Yeah, naka-twice pa lang kayo ng receipt, di ba? Pangatlo yung today. Okay, tama yun. Sobrang. Next. Mr. Gutierrez. Delikado dito, tas. Okay. Mr. Gutierrez, let's go back to the term capital as discussed in the Roy versus Hermosa case. Can you still remember?
So, in the Roy versus Herbosa case, so, the Supreme Court held here that the, Memorandum Circular number 8 was, valid and constitutional. And it was bolstered in this case that the term capital refers to as the, outstanding capital share of the company. Also, in this case, it was highlighted that the said memorandum circular has a two-pronged test. So, this two-pronged test.
That's my next question. Good.
So, the two-pronged test pertains to the number of the two-pronged test here that pertains to the number of outstanding shares and the number of voting shares that a company should should consider in determining the nationality of the corporation. So, in order for the company to be determined as a Filipino, that it has a Filipino nationality, it has to pass the two-pronged test of the memorandum circular.
Okay, so when the Supreme Court held that one part of the two-pronged test includes shares of stock entitled to vote,
Yes.
diba? Yun yung isa. And
Yes.
then the other is the outstanding shares of stock. So, shares of stock entitled to vote, is it limited to the common shares?
No po, attorney.
So, there are other shares that can vote.
Yes po, attorney. As long as the share has the capacity or it has the right to vote into the company's rules po.
Alright. But, can you remove the voting capacity of a common share?
No po, attorney. It's a fixed po.
Yes. All common stocks is always stock. Tama ba?
Common stock.
Remember that? It's there somewhere. Wala na yung next page. Okay, let's go to piercing of the corporate veil. Give me the general rule and then give me the exception.
So the general ruling before the court pierce the corporate veil is that officers, directors, and members of a corporation cannot be held liable into the liabilities of the corporation. Exception thereto is that when the members, officers, and directors acted with bad faith, malice, or fraud occurred.
Alright. Last, do you still remember the difference of outsider and insider piercing?
Yes po, attorney.
Okay.
So, reverse outsider, outsider piercing. This is a type of reverse piercing wherein the claimant wants to target the assets of a corporation in claiming in claiming damages from a suit water. On the other hand, insider reverse piercing. This is a scenario wherein the officers, member, or stockholders utilizes the individuality of a corporation to avoid liabilities from any suit.
Alright, thank you. Mr. De La Cruz. So, okay, explain the doctrine of separate juridical personality.
Okay. So the doctrine of the set of separate juridical personality refers that the liabilities and obligation of a corporation cannot be passed through to its stockholders or board of directors.
Okay. No, I think the doctrine of separate corporate juridical personality is that the personality of the corporation is
Different from its shareholders.
it's a separate entity. That's
Yes.
its shareholders, officers. But for the purposes of this meeting, we will, yung mga involved lang talaga ng characters are usually the corporate officers or the directors. And class heads up, maladaanan natin yung mga portion where, example, there's sharing of directors between two corporations. And sometimes it's, hindi ko alam kung nadaanan yung sa meetings, but in the cases, it was also mentioned that, the interlocking directors can be used as an indicator that there's, that another corporation can be held as a mere alter ego of, but it's not always ruled that way, but it can be an indicator. So it's not just limited to officers, but it can also involve the directors. Yung mga characters din sa story natin pala. Next, how about the doctrine of limited liability?
So the doctrine of limited liability refers that the debts of the creditors who has interest who has paid for interest to the corporation can claim up to the extent of the corporation's capital loan.
Up to the extent of the capital. Parang piso na lang, and then there's a list of 100 creditors. Tapos magsasara na.
Then-
What will happen to the rest?
Then there should be a hierarchy dito. First is unsecured creditors with priority counter attorney. Then secured creditors with priority. Then third po is unsecured creditors po. Then if that's the case po, the debts such as taxes, wages, and the government dues must be paid first before the creditors themselves are there.
Alright, so let's go to the case of Koji Yasuma. So this case is about, can you still remember the case?
Okay, fast lang po, fast lang.
Okay, I'll give you some facts. Okay, si Devilla dito, yung president ng Cordillera Mining Corporation has a 1.3 million loan from Yasuma.
Medyo nagaling ba?
Nagaling na. And then, it was secured by real estate mortgages. But since the Villa was the president that time, and then Yasuma, the corporation, filed a collection suit against the Villa. And then, ang issue dito is, wait, nasa na ako? Okay, yung property kasi dito is, I remember it's the property. Wait, there's a personal loan.
Yes. Tapos, nireceive ko ng corporation, if I remember correctly.
Yeah.
So, if I remember correctly, the Supreme Court upheld that the corporation cannot be held liable for the low personal loan of
Of the Villa.
the Villa company, because first, the corporation received the loan proceeds from the Villa in good faith quarterly. And second, the Villa acted in his own capacity, acted in his personal capacity when contracted that loan. Since if I remember correctly, nalugi po yung corporation.
Yes.
Since the corporation went bankrupt in that case, the corporate, although the creditors can only claim up to the extent of the corporation's assets. However, in that case, the Villa's loan proceeds will take part of the corporation's capital because the corporation receives the proceeds in good faith.
Alright, thank you, Mr. Next, Ms. Abebon. Oo nga. Sorry, class. Okay, let's go to the case of Villanueva versus Paul. This is about the Anti-Graft Corrupt Practices Act. Do you remember?
The owner of the corporation and sole proprietorship.
Wait. Maalala. Binasa ko last week eh. Yeah, this is the case about the Senator Tito Soto's disaster program. Okay. Sige. The court will discuss the liability of a private individual. So, can you discuss how the doctrine of conspiracy and piercing the corporate veil are used to establish criminal liability? Kasi as general rule, ang kinuhold ng liable for Graft and Corrupt Practices Act are government officials, government employees, etc. But for this particular case, there's a private individual involved. So paano nangyari yun? Through the corporate, the piercing.
In this case, attorney Villanueva's corporation and the sole proprietorship participated in a bidding wherein the corporation and the sole proprietorship get the award, and then because of that, after the COA's audit, it was found out that Villanueva was the owner of the two entity. And then because of that, Villanueva and the mayor and the public officials were held liable for corrupt practices. Is it because what Villanueva have done and the public officials contradicted to the law against law prohibiting corrupt practices at in bidding?
Okay, so what does this case has to do with the piercing? Where's the piercing here? Or did it have account?
In this case, attorney, the piercing of corporate affection was given when when Villanueva, because Villanueva was the owner of 99% of the shares of the corporation, and because of
So what doctrine was, di ba there are three instances where piercing can be used. Which one is it for this case? Yeah, kasi you mentioned they share the same owner, right? And sabay sila nag-bidding. And then, so which one was it?
it was fraud attorney.
This fraud. And so, do you mean to say it's just an instrumentality? The other one is just an instrumentality? Used to kami ito.
No, actually, attorney, in alter ego cases, fraud is not necessary.
Yeah, it's alter ego. I'm looking for the alter ego, yeah. So this case involves the alter ego doctrine again. Okay, and then continue. Alter ego.
Yes, it was an alter ego case because Villanueva was the owner of the corporation and then the sole proprietorship. And then since he used that instrumentality or the entities to make sure that at least one or both of the entities will get the award, the court held Villanueva to be liable of the Corrupt Practices Act along with the public officials.
Along with the public officials. Okay, let's go to the next case. It's the Mercalum case. This is again about the government. Natin, no? Wala naman. I don't have a COA student again, right? Okay, last semester I have 3 COA students. So they all work in COA. And luckily we're not discussing this. Yeah, but it's fun to have COA. Are there people here who work in the government? Who? Oo nga. Okay, saan? RTC.
BAR.
BIR.
Local government.
Local.
MPC po.
MPC.
Beer
Okay, MPC.
MIA.
MIA. So, yeah, you guys are you familiar with how bidding works? Well, it's too technical to the point that if you can master how the law works, okay, on its face, the bidding is actually good. A habang process to make sure the documents submitted are all checked by several people, the technicality, the legal, the operational requirements, etc. But then again, there are bidders like what happened to the other case, the hospital case, the Villanueva case, na ang ginagawa nila, pareho bid, kumbaga, pollution na, sabay, pare-pareho sila, nag-usap na sila. I'm not accusing any government entity of doing this, but it happens na I heard from my friends that there might be instances where naka-allocate na kung kanino maa-award, pero sabay-sabay silang mag-bidding para hindi halata. But they're always the people, they're always the entities who bids for different. But they know who will bid. And then, the process is so tedious na hindi siya madaling pasukin ng ordinary entity. And it's actually good kasi technically, make sure ng government na qualified talaga to deliver the service yung mananalo sa bidding. At the same time, it's too tedious na hindi siya kayang pasukin ng regular entities. unless may connection ka sa loob or naiintindihan mo yung process, and hindi ka nila basta-basta mapapasukin allegedly sa sistema kung hindi mo alam paano gumagana ang sistema. So, that's all I can say about it. Kasi, ayun, I also worked in the government before. I participated, I reviewed documents pertaining to billings in the government, hundreds of millions worth of projects. And I saw the documentation na ibang sinasabi. Diyos ko, ganyan ka kapal yung billing documents that you have to check every billing. So, alam mo yun, on its face, it looks so tedious enough to make sure na protected ang people. Yeah. So, let's continue. Ayoko na pag-usapan ng part na to. Let's continue. Let's go to Marika Lu case. Do you still remember the Marika Lu case with the G holdings?
Yes.
Okay. So, in this case, the doctrine of piercing the corporate veil was also mentioned, right? So, how did the Supreme Court rule for this particular case?
G Holdings attorney was not held liable in this case. It's because even if G Holdings owns 90% of the share of Marika Lu, it did not act as an alter ego of Marika Lu because the court held in this case that even if a corporation or the stockholder owns mostly all of the shares of a corporation, as long as it did not acted to violate any crime or to
Did not commit any of the elements which constitutes
the offense attorney. The other entity will not be held liable.
okay. It was mentioned a while ago the elements of the elements of alter ego doctrine, the instrumentality, the fraud, and the harm. Instrumentality, the fraud, and the harm. So in this case, what's the ruling of the Supreme Court for each? Kasi di ba, isa-isa niya yan. Actually, nung minimemorize ko ito before, di ba, there's three types of piercing. Yeah. Applies only in three areas. Piercing. Ang demonis ko ay DFA. Di ba? It's public convenience, fraud, and then alter ego. It's DFA. So, we're not associating this with DFA, but, just for easy reference. And then for alter ego doctrine, there's three elements naman. Instrumentality, fraud, and harm. In this case, how was it applied?
In control test attorney, G Holdings did not or has no control over the act of the Marika Lu. It is a separate entity apart from the Marika Lu. And for the fraud, there was no fraud committed by G Holdings. It both the shares that was it bought the shares from the government, and then the employees of the Marika Lu was employee of Marika Lu. They are not employee of the holdings during that time. And then with control, fraud, harm, and with harm attorney, there was no intent for G Holdings to do such act or to harm anyone or to harm the employees of Marika Lu. And since there was no elements or the absence of any of the elements will not make the corporation liable.
Okay, so 3 elements siya. Kailangan 3. Hindi pwedeng isa lang. But for alter ego, do you have to satisfy all the DFAs? For alter ego? I mean, for the doctrine, for the principle of corporate faith, do you have to concur that all the DFA are present?
No,
Just one. But for elements, it has to be. Pag kulang ng isa, it will not be
the corporation pursuing of the corporate fiction will not be
through alter ego will not possible. Alright. Maybe this is about. Next. Nakasunod pa, class? Kayo pa? Next, Miss Panibatan. Okay, sa kabila na. Miss Panibatan, let's discuss about the Naranigan case. There's 2 Naranigans, right? Okay, so, but the other one is just a record regarding the MR. Umulit lang eh. So, what's the issue in this case ba? Ano pinag-aawayan nila?
The issue in this case is regarding the nationality of the corporation. The Naranigel,
The 3 corps.
3 corporations.
That's called the ABC.
The ABC corporations. It is with regards to the MPSC or the mining shared agreements. And Redmond, the respondent here contested about the application of the ABC corporation with regards to the MPSA. And they mentioned that these corporations were not really Filipino-owned, but it is owned by a Canadian firm under BPFI, which is by a Canadian firm. However, the ABC Corporation contested that they are Filipino-owned corporation with regards to the control test. They satisfy the control test, 60% ownership by Filipinos. So the issue in this case is whether the grandfather will be used to determine the nationality of ABC Corporation. And the Supreme Court ruled that yes, because they ruled that grandfather rule or grandfather test should be used because when there is doubt in terms of the nationality of the corporation, we should look towards more specific or dig deeper with regards to the ownership of the corporation. Here, the Supreme Court found out that despite using control test, it only shows that they are 60% Filipino-owned. However, if you dig deeper, those 60% Filipino ownership are funded by a Canadian firm, which is all foreign nationals. So they are all foreign nationals, and they ruled that with regards to that ruling, Naranigal filed a motion for reconsideration with the Supreme Court, stating that they should only use control test and that their corporations passed the control test. However, the court denied the motion for reconsideration with finality, stating that when there is doubt, control test is not the only test to be used because it can be used by foreign nationals to circumvent the ownership of the Filipino corporation.
Alright, so in Naranigan case, which one of the corporations were declared foreign-owned? Which one of the corporations were declared as lumampas sa 64?
The Naranigal.
Di ba there's 3 corporations there?
I forgot the other.
Okay, the one, so si Corporation A, si Corporation B, si Corporation C. Sino doon yung rule na this is about the mining, this is the case about the mining permit, right? So, did the Supreme Court rule that they can all be granted the mining permit? No. All of them?
Only the first corporation. If I'm not mistaken, corporation.
Just one corporation?
And the letter S.
Just two?
Okay. No, attorney, all of them.
All of them?
Because
All of them?
all of them are under BPMI.
Yeah, akala ko ako na rin dito eh. Pero yeah, all of them, all of them. Kasi I remember, gidraft pa yan isa-isa ng Supreme Court eh. Just to place gano'ng kalayo yung option. I will not torture you with that kind of, ano naman, that kind of exam. Just make sure na in case mag-computation ng bar exam, aralin nyo. Okay? But for our class, since midterm season pa lang, mag-iisipan ko sa finance, pero since midterms pa lang, at hindi nyo pa naiintindihan yung types of stuff, parang kasama ko ng mga tao, pa-exam ko na sa inyo agad. We'll see, we'll see. Let's go to the next case. The case of Team Pacific Corporation versus Laila Parente. This is about labor law again, the entrenchment. Okay, so in this case, what happened is that is the corporation held liable?
Yes, the corporation was held liable for illegal dismissal of China Parente. However, the Supreme Court they modified the decision, dismissing the complaint against the president. Because it's the president of the corporation.
Why? He's the one who terminated the respondent.
Yes, attorney. However, the court ruled that for the liability of corporate officers, it they can be liable in illegal dismissal cases if they show malice or bad faith in terms of terminating their employees. However, in this case, the court ruled that Laila Parente or the president of the corporation has no malice in terms of terminating Laila Parente. So the separate juridical personality should be applied and the corporation will be held liable for not following the notice for illegal dismissal.
Alright, thank you, Ms. Malika. So in this case, it shows na executor lang yung presidente. Hindi naman siya yung nag-decide. Diba? Kasi in this case, there's retrenchment. There was a retrenchment order ng corporation itself. It's not just the decision of just one person. It just so happens na si president yung nag-execute yung decision. So, medyo mahirap to when you work in a corporation. Kasi, syempre, bibigyan ka ng order. And then, ikaw yung mag-execute. So, usually, damay ka. Ikaw yung pag-iinan. Gano'n pag-HR personnel ka. Usually, sa mga labor cases, dinadamay nila, not just the president, but also the HR officer. So, just a tip, if you work in this particular, diba, nakabili ka na ng kumpanya, or ginawa kang presidente ng kumpanya, or HR ka ng kumpanya, or better yet, nasa legal office ka ng isang company, and you have to defend, of course, not just the company, but also, example, you have to defend the officers as well. You can justify, or you are a lawyer of one of the officers accused in a labor dispute. Just make sure na ang isa sa mga hihingit yung resibo ay there's an order given to them to dismiss that person. And sino nagde-decide when it comes to corporations? The HR? The HR usually endorses. It's usually discussed by the management. And if it's sobrang lalang matter, depending sa industry, sa totoo lang, depending sa industry, from management, they bring it up to the board. And then usually it's the board who decides. Pero depende sa laki nung impact nung scenario. Kasi example, tatanggalin nila yung isang computer analyst ng corporation. I don't think the board will be discussing just one dismissal of a person, lalo na kung yung grounds were satisfied based on the policy, the attendance policy, the code of conduct, etc. So it's, kumbaga, may rules na na-approved about it. Ang ina-approve lang ng board doon usually ay yung policy itself. As to how you apply it, it's the role of the management already. So, but when it comes to example, malalaking decisions, like retrenchment, ibig sabihin, kasi you have to show na, di ba? It was discussed somewhere here, kasi maraming illegal dismissal cases here. You have to show that there are sufficient justifications to show na retrenchment must be executed, and it's not a small matter na managerial lang yun yung discuss. It's usually brought out to the board, and if there's an order, sabi dito, and then in-execute lang naman yung Mr. President. Kawawa naman si Mr. President. Hindi naman niya kasalanan ng naging presidente siya na pinag-abutan siya nung time na madi-dismiss yung person dahil sa retrenchment na nangyari sa corporation. Mr. Mahalina. Ay, ito pala yun. Mr. Mahalina, let's go to the Cali case. Okay, sa Cali na tayo. Do you remember the Cali case? Yung may anak siya, tapos
One who
yung na-disown, na-disinherit siya. Oo. Oo. So, what happened in this case muna?
there is there is a corporation created by Karen. So that he can and with her with his 4 children, they incorporated that and transferred properties as part of the shares of those children. However, PAS was not included in that corporation.
Si Paz. Yeah, kawawa si Paz. No. Okay, good.
So PAS alleged that she has an interest in that properties based on what Kali made. The corporation was made as a tool or as a business conduit to deprive us of his interest in the properties. So, based on the issue here is whether or not the corporation is a mere alter ego of the corporators or those. Then the Supreme Court.
Why alter ego? Was it created to... Sige, sige.
So the Supreme Court held that the Supreme Court granted the petition.
Granted the petition. So there's, remember kanina, there's DFA, right? Defeat of public convenience, fraud, and alter ego. This particular case, which one ito? DFA.
Alter ego.
Alter ego. So you mean to say there's another corporation involved here?
Ano?
Or another entity involved? Dalawa na lang. F na lang at saka D.
I believe the corporation was used to the public convenience.
Defeat public convenience. Why? That's the particular case, right? The DFA. Okay.
More of alter ego.
Alter ego. Okay, sige. Wait lang. Dyan ka lang. Who votes other letters. Who votes for defeat of public opinion? O sige guys, pikit. Pikit! Ayoko makita niyo yung boto ng katabi. I just wanna see. Okay, class. Sino? Pikit na class, pikit. Who votes for defeat of public convenience without looking sa katabi? Who votes for ano isa? Fraud? Ano yung boto ng iba? Okay. Alter ego. Okay. Sige, pwede na yung mumulat. Class, it may be D or F. Kasi remember, open your copy of the Bertalutis. Sige, ikaw din. Okay, class, para lang makita nyo, marami nagtaas sa F. May nagtaas din sa D. May nagtaas din sa A. Wala lang, para lang aware kayo. Hindi nyo nakita eh. Yeah. So, class, pwede siyang defeat of public convenience because you are evading an obligation. There's an obligation to give him at to give us a share, right? Pero, in-skip kasi siya. Pero at the same time, there's fraud. So, we can consider it D or F kung saan siya mas malapit. And if itanong mo siya sa exam, you can answer either the D or the F, provided you can justify. Okay? I'll be looking at the justification, not whether you are particularly correct verbatim galing sa case. Okay? Oo, ang dami niyo. Kung gusto niyo magtaas ulit ng kamay para kita niyo na ngayon. Okay, sino kanina yung bumoto ng D? O, tingnan mo, nakataas na ng maayos yung mga kamay. D, F. Yeah, ganyan ay marami. And then the A. Boy, may nagtaas ng A kanina. Okay, sige, but let's continue. Ano pa ba? Wala na dito sa case na to, yun lang ang point nito. So, how did the Supreme Court, paano daw makukuha ni Paz yung share niya and nilagay na sa corporation? Eh, diba, ang corporation ay naka-separate juridical personality. So, paano na daw? They will pierce the veil. And it was remanded by the Supreme Court to the RTC to fix the legitimate. The next case is about, there's another case about total. Yeah. The total. Nagpalit ng pangalan. This is the change of name case. And then, he used that to justify na, okay, iba na yung entity namin, so iba na yung obligation. So, how did the Supreme Court rule in this case?
The Supreme Court ruled that the new names business and business property so that the corporation demonstrate the liabilities of the whole corporation.
Can you discuss the case?
Correct.
Oh, sige, you can look at your own. This is a distributorship agreement
Assigning rights.
to another entity. But then again, that corporation is really that's overflow. And then the what?
Just to remove the bad speech
Oh,
of the whole corporation.
okay. And then they entered a new distributorship agreement, right? And then after that, nagkasuhan sila. So, si Liv, who is the president of Tire Plus, na originally may engagement with Total,
the outstanding diligence. That's however, the new corporation, which is the Sobrero Industrial Sales Corporation.
The super group. Okay, first, is the obligation of Tire Plus still collect, can Total still collect from Tire Plus?
Yes.
They can. Why?
Because the Sobrero is just used as a business one or just an alter ego for the environment. So for that's all.
And then, ano yung involvement dito ni the president?
Whether or not he's solidarity liable to the
Why? What did he do? Anong kasalanan niya na sininaman? Wow, naman. Wala, dami pang di natatawa. Oh my God. Ang hirap na yung questions.
because he's guilty of bad behavior.
Okay.
And there's malice in making the
Why? What did he do? Bakit siya naging, bakit malicious daw yung ginawa niya? What's being held as malicious? Anong pagkakamali niya here?
because Slim uses the corporation as an alter ego perfect way for reach the contractual obligation of the corporation.
Alright, sige. Thank you, Mr. Mahal. So, class here, in this case, Mr. Lim, the Tire Plus president, dealt with Total in that way. So, he misled Total, ang dami niyang pinagagagawa, nagpa-new agreement pa siya, nag-change of name lang naman sila. So, did we discuss already the change of name and its impact to corporations?
Yes.
Diba? Day 1. Last week. Week 2, diba? Changing the name of a corporation does not mean you have a new corporation. It's just a change of name, but you're still the same corporation with the same liabilities, with the same obligations. And then there were lots of instances here where Lim dealt in bad faith. They really... Okay, kayo na lang magbasa, class. Andito lahat, kinulayan ko para sa page 81. Anyway, it's the discussion about the liability of Tire Plus president and Carlo Lim. Please mark it, baka lumabas sa exam. Next. Mr. Mirabite. Mr. Mirabite, let's go to... Okay, have you heard about the Nell Doctrine? Nell Doctrine. Okay, the Nell Doctrine is the one mentioned in the Maricalo case about, no, it's not directly mentioned as Nell Doctrine, but it's usually called Nell. Nell. As to why, I don't know. But it's called Nell Doctrine. And it's about the sale or transfer of corporate assets. So can you explain to us what's the impact of transferring assets into the personality of the corporation?
When transferring an assets of an entity to another entity, it does not change the ownership of the seller, it does not change the ownership composition of the seller entity. While in the next question number 20, while in selling the stocks to another entity, it is the selling of the shares of stocks to another entity. The ownership, the composition, or the ownership of the corporation that the shares are being sold is changing to the buyer.
What if Corporation A sell or transfer all of its assets to Corporation B? Does that mean that Corporation B will now be held liable for all the debts and liabilities of Corporation A?
No, attorney. If the selling is particularly selling is limited to the assets of the corporation, the liability does not transfer to the buyer of the such assets. While if the selling is the stockholders stocks to the another entity, the liability transfers.
How about is that the same across all instances? That when you sell all your assets, it will not transfer the liabilities and obligations.
It's not absolute, attorney. That's the general rule. Because if you sell an assets where it includes liabilities such as if you sell manufacturing plant, which includes the workers. Therefore, the liability to the arising whatever liability that may arise to that sale may also be transferred to the buyer of the assets.
Alright. In the case of marital law, there's a discussion about the exemptions when the transfer of all assets of the corporation can also make the transferee liable of liable of debts and liabilities. Do you remember some of them? There's 4.
Remembering ito.
Sige. Yeah, nandun sa part ng discussion about saan na ba yun? Protest, part 2, protest. How about, sige, I'll change the question. How about, let's discuss about, see, we're still in marital case. Diba we discussed about the protest? For example, if they are sharing the same office or business location, can we automatically confirm that there's fraud and there's alter ego between the corporations sharing the same office?
No po, attorney.
How about commingling of funds?
Commingling of funds po.
Yes.
No rin po, attorney.
No, but it may.
It may if the funds is common shares that which shows that both the company has a control have controls to that.
Last question. How do we define proximate costs?
Ang proximate cost, attorney, if the harm that has been incurred by an individual or an entity is directly connected to the fraud made by an entity.
Alright, thank you, Mr. Miller. Next person. Miss Nacario. Miss Nacario, let's go to the case of Atienza. Here in this case, do you remember the case? Okay, this is the case about the boat. There's a boat here, right? Yeah. So there's a boat. Sige, tell us the story of this case. The facts pala.
What happened here, attorney, there's an, they bought the boat to this specific person, and apparently the item that was delivered was only demo unit, and after a few months they got
Tama ba? Boat to? Sabi ng vessel eh.
okay, it's only a demo unit, attorney, and it malfunctioned after a few months, and then the seller offered that they will process the repair and maintain, and they assure the buyer that it is well conditioned, attorney. Now it comes to a point where it cannot be used anymore, and they sue the corporation as well as the Atienza. The Supreme Court ruled here that Atienza is
Wait, what's the
the issue is whether or not Atienza is also liable, solidarily liable with the company and corporation, attorney. And the Supreme Court here ruled that yes, he is solidarily liable with the corporation because he acted with bad faith and malice, attorney. The acts of Atienza for assuring the buyer that it is a good product, and also for fraud because the item was only a demo unit and he was aware of it.
Okay. Again, in this case, it was enumerated. Section 30's enumeration was again mentioned as to when you can hold a corporate officer liable for a corporate act. So, do you remember any? It says,
An officer of a corporation may be liable, attorney, if first they willfully or knowingly assent to an unlawful act, and if they acted in bad faith or malice. But it is provided as well that the bad faith should be provided with concrete evidence that it cannot be presumed.
alright, thank you, Mr. Carter. Thank you. Next. Mr. Bitwali. Yung picture mo pang civil service. May name and then may signature. Ready na pang bar actually. Ganito rin sa bar eh. You have to write your name and then your signature sa ibabaw. Fairness medyo maaga ng
PDS lang.
PDS lang ba? Medyo maaga kasi ng 2 years for Okay, let's go to the discussion about moral damages. So, what is moral damages?
Attorney, moral damages, one that is given or granted by the court to a particular person or particular plaintiff in which it is being awarded
Just the plaintiff. What if it's the respondent who wins the case? And then
or the respondent
the party.
or the party. If the particular suit make them or targeted the moral, the shock or the social, if you will need a particular aspect of the person.
Okay. So in terms of a corporation, can a corporation feel like the shock you mentioned, the stress, the sleepless nights? So can a corporation have these, feelings?
Actually, attorney, the general
No, just answer my question first.
okay.
Oo. Can a does a corporation has feelings?
No other.
No. So, but can they be awarded?
Yes, they can.
They can be awarded. But what's the general rule?
The general rule attorneys that a corporation cannot be awarded immoral damages. But the exception to the particular rule is that when a corporation is in good reputation and there's a social humiliation that targeted their reputation, then the court may grant immoral damage to that corporation.
Okay. Why do we have this general rule that you cannot award moral damages to a corporation?
Because attorney, the very essence of the moral
It's the very essence. Okay, continue.
or the essence of the essence of having immoral damages is to award or to relieve one's feelings, anguish, anxiety, or anger, or feelings. However, in the corporation attorney, as we have mentioned, there's no a corporation is a fictional character or a fiction entity which has no feelings or a cannot feel anguish, anxiety, or anger.
And then, how can a corporation recover moral damages? Is there a specific requirement?
If it has, if that corporation proved that it acted in good reputation and there's a social humiliation, then the court may grant moral damages.
And it must be the proximate result of the harm done by another. Okay. I believe I assigned you the BPIs before, right?
Di ba
Yung nag-away sila.
Family.
Lahat naman nag-away. Wala ka ba?
Yes,
The
yes.
BPI family and the ano are
Sa name.
okay, it's just the name. But in the book, there is a mention about the BPI discussed under the topic of moral damages. If you've read the book, BPI is one of those corporations. Okay, sige, I'll just give the question. For example, if it's BPI and BPI wants to claim for moral damages. You mentioned a while ago that okay, is it required to have goodwill when it comes to claiming moral damages?
Yes, attorney.
What is goodwill?
Goodwill attorney, that the party is not, or that the party does not make any wrongdoing that will make the reputation not in good terms.
Alright. Does goodwill have value?
In other aspect of it, we have what we call the goodwill ban, but yes, attorney, it has value.
Okay, thank you, Mr. Higuayo. Okay, so let's discuss moral damages first before we okay, class. Goodwill. Let's start with goodwill. You know why one of the reasons why the trademark law exists. I mean, under the intellectual property code, we have the trademark, di ba, discussed. They protect the name of their corporation or the name of their product and they make sure that it's just affiliated with their corporation or with their entity. Why? Because of goodwill. Halimbawa, when you study the intellectual property law soon, madadaanan nyo yung calling case. It's a case about merong isang corporation. Alam mo yung calling, di ba? Yung appliances. Have you heard of that? The brand? Yeah. And then merong isang dun sa product, eh sila, gusto din nilang maging part ng name ng corporation nila yung Colin, maging trademark. And then, yung original Colin, yung masikat na Colin, they're claiming na hindi niya pwedeng gamitin yan kasi that is particularly affiliated with our products. And yung products namin, may pinaninindigan, meron niyang reputation, meron niyang standing when it comes to how people perceive appliances made or produced by Colin. So that's how we can illustrate what goodwill is. Goodwill is the name, the reputation, the branding. It has value, yes. The more na mas nakikilala yung brand mo, the more na mas na-affiliate yung good, positive impression about your products, the more na mas binibili ng tao, mas tinatangkilik yung products mo, yung services mo. Ano pa bang local example niyan? Bello and Ivy. Si Dr. Bello and si Dr. Ivy, when it comes to their field, pag sinabi dati, diba, only Bello touches my skin, who touches yours? So, kumbaga, when it comes to those particular services, usually si Dr. Bello yun. And example, may gumamit ng name niya na another cosmetic doctor and all, claiming na he's also Bello. Alam mo yun, yung mga Pinoy na mahilig dikit ng pangalan, ay, Bello din yung apelido ko, baka pwede nyo na maging doctor, tapos mag-brand ako, ganun. Using the name to be affiliated with another entity. So, it's because of goodwill. Nagigets niyo ba? There's a particular definition of goodwill. You can search about it. But the description is something like that. Na make sure, it all boils down to reputation and standing. When it comes to how other people perceive or other entity perceives your corporation, your product, your services, etc. Let's go to the next one. Miss Order Therapisa. Let's go to the tapos sila ng Roy versus Rosa. Stereotype, please. Still remember? Redundancy. Sige, mag-isip ako ng BPO. Tapos ayaw niya mag-exam kung pinapalipat siya sa next na account. And then, natanggal siya. This is number 3. I type 5. Yeah, there are usually 2 questions with regard to this guys and cases. The first one was the company held liable with the Supreme Court for the dismissal of the respondent? Sarah also responds.
I remember correctly, yes, the company was not liable by the Supreme Court.
Why?
Because the company did not prove with clear and convincing evidence that there was redundancy.
How about the person, the president? I think it was the president. Ano ba? Ano yung president name? The officers pala. It's the officers. Are the officers for this case held liable?
No po, because according to the doctrine of severability of personality, the corporation has a distinct and separate personality from the officers.
Distinct and separate personality about that. And then let's go next. The preparation, pagtapos kong basahin yung libro, pagtapos kong basahin yung cases, magpe-prepare pa ako ng 40, ilan kayo ulit? 21. 40 to told deep Friday na lang. And I regret the decision. Choosing Friday, ang hirap. Okay, let's go next to the topic of jurisdiction over liability. What do you remember about this topic? Page 126.
I'm not sure, but I think this refers the jurisdiction in liability refers not on the intention, but on how the company operated.
Okay, sige. Let's just move on. Let's go next to the topic about ano ba yung tinatawag? Yung naitanong yung economic realities masyado malala niya.
Attorney, may nalala.
Okay, okay. Okay, so continue.
I think that jurisdiction in liability in order to acquire jurisdiction over the liability, the complainant must allege the fraud or the bad faith committed, and second, the fraud or the bad faith must be proven with clear and convincing evidence.
Okay. How about the topic about um, next time na lang yung bago. May nagbasa ba ng bago? Oh, gusto mo yung sa yung bago, Okay. Do you guys read the SEC opinions I give? Did you search? Did you even search for it?
Yes.
Nahanap niyo naman yung iba?
Yes.
Nahanap niyo naman pala. Bakit hindi niyo binabasa? I actually asked that several times last meeting and nobody answered anything from the case, from the SEC, and those are short cases lang. Those are just 5 cases compared to the whole long scroll, na sobrang haba. You can read the Roy versus Remote, but you cannot read the SEC opinions. That's just it's hard. It's so ironic. Okay, last question. What's the hierarchy of the tests for the nationality? Diba, there's a hierarchy. Kung hindi ito na, first, ito muna. And then, ito. And then, kapag mas malalim ito. Ito na po. The most basic test to identify the nationality of the corporation is
The incorporation
the
test.
incorporation test. What does it provide? Kasi nakalimutan ko baka hindi ko nga pala discuss yung incorporation test.
Incorporation test means that the nationality of the corporation is determined by the place where the corporation was organized or incorporated.
When are we going to the control test? Several cases discussed why we use control test.
We move to the control test if there is doubt as to the
Wait, doubt is for the grandfather.
control. corporations need to be 60% owned by Filipinos.
Why? Just 60, like everybody 60-40.
So po, some corporations need 100% is like the Almasilla. And it's because in accordance with the Constitution, it's because it's provided in the Constitution po.
So sabi ng Constitution, gamitin natin yung control test?
Ano?
Na-excite ako ng class. Kasi hindi ko nadaanan yun, oh my God. Wala yung sa Constitution. Why do we need to use control test? If we can determine in the first place that very incorporated can be the determining factor for your nationality.
Maybe because some
Why maybe?
okay. Some corporations are incorporated here in the Philippines, but the stockholders are foreigners.
And then,
And so
sige, nasa tamang lang kasi nito.
And so, we need to use the control test to establish that the corporation is a Filipino corporation.
Yes, and to make sure that the ownership rule of the required by the law or the constitution are followed. Yeah, okay, nasa control test ka
Sorry,
na.
sorry.
So where do you move to grandfather rule?
We move to
That's the
the
exciting part na tayo.
grandfather rule if there is doubt that the beneficial ownership and control.
Of the court. Okay, sige. Okay. Class, I finished all the questions already. We still have ilang case na lang? 1, 2, 3. Kaya niyo pa ba? I'll just call one more. Wait. There's six people here. Intellect. And that's enumerated. Candidate number 1 is Soledad. Candidate number 2 is Mr. Mahomo. Candidate number 3 is Mr. Corpo. Number 4, Mr. Coral. Tama ba? Hindi naman si Mr. Coral. Ayun. Candidate number 5, Ms. Albino. And number 6, Mr. Patrickela. Albino. Absent. Okay, so limang candidates na lang. We will choose one. Ano ba tayo humikilig? Okay, right. Who wants to give me a number?
Stop at or middle.
Hindi, leader nasa deck eh. May vice leader pa. May leader sa leader. Okay, give me a number. 3. Okay.
Ano kayo, sir?
Ito na. 1, 2, 3. Miss Soledad. At ikaw na naman ang dulo ng presentation natin today. Okay, let's go to the case of... Grabe, Beatle, inaapikan nila. Okay, let's go to the case of Raquel. Kasi ito yung may parent company. Okay, discuss me the case of Raquel.
Raquel po was employee of BN in Home Finance po in Corpo. Then, during the time of her employment po, he was transferred to different PNP entities po. And during po, or after he was being terminated, his employer, her employer po was terminated. And then she filed po for illegal dismissal. But the question here po is he filed a complaint against PNB Global and PNB Person. PNB po stated that PNB entity is a separate juridical have a separate juridical personality from its subsidiary corporation law, which is PNP Global. So the issue here is whether the PNP can be held liable po against the illegal dismissal complaint of Raquel. The Supreme Court po stated that PNP Global, PNP po attorney is liable po for the illegal dismissal of Raquel in that case po, despite kasi she was a formally employee of the PNP in Hong Kong po.
With that, which one was used in this case? Kasi di ba may piercing? Here. Which one? The D, the F, or the A?
At the A po, the
The
alter.
alter ego. Why?
In this case po, attorney, the alter ego po, or the instrumentality, if the PNP Global po is so organized, controlled, and managed by PNP pa rin naman po. So therefore,
The parent.
the parent company. So therefore po, the PNP Global is a instrumentality lang po of PNP.
And the tenure was preserved. She was just being transferred from one to another. The employment, she's still a regular employee throughout. Okay, let's compare that to the ruling in Montilla. The here also, it's also about a parent, the holding company, and a subsidiary.
In Montilla attorney, it is also po that the holding corporation po attorney. In Montilla po is an employee where employees po during that time was promised po of the money claims from Maritalong attorney. So by that po, the employees who wanted po to demanding the money claims attorney, they not only filed the complaint against the Maritalong, but they also filed a complaint against the G Holdings, arguing that G Holdings attorney own almost po of the shares po of Maritalong, and also they are the parent corporation po of Maritalong. And the issue here po is whether or not Maritalong can be held liable po for the money claims or obligations of its subsidiary corporation. The Supreme Court po stated that Maritalong, despite G Holdings, despite being the parent company or parent corporation of Maritalong, they still have different, separate and distinct juridical personality.
Alright. Kaya mo ba bilis na lang? The last case is the Malati case. Kasi wala na tayong magagawa. Ikaw naman yung pinawag natin. Tapos gusto ka na.
Malate attorney, Malate Construction Development Corporation is a real estate corporation. They entered to a agreement, marketing agreement with Aramco attorney, which in that agreement po, Aramco will sell po the housing in Cavite. And by that agreement po, Aramco started to sell units po from commission po. They were promised for a commission in every unit Aramco will sell. And during Aramco sold units na po, and then he demanded payment from Malate and its president po, Olivares. And Malate refused po to pay. Then the Aramco po filed a complaint demanding payment.
There's always two questions here. One is the company held liable, and number two is was Olivares held liable?
The company po or the Malate was not liable to pay for the commission that was promised to Aramco. And the president po, Olivares, was not held liable, stating that the president po and then the corporation have a distinct and separate personality.
Alright, several cases to discuss the piercing, the reverse piercing, and all. Parang nag-assign ako ng 20 cases just for piercing and ano. And they provided guidance for everything. But for this particular class, I just wanna know if you guys understand piercing na. Piercing and then the reverse and then the separate corporate juridical and personal. And then, ano ba yun? Yeah, and then the piercing. Pero okay naman na tayo. I think okay na tayo for that. So next meeting, we'll enter capital affairs. Exciting. So, next meeting wala akong masyadong inassign na case for next meeting. But you will have a case from I'll just give you two essay questions. Two essay questions in preparation for your midterm exam. Kasi, I always do this exercise just to prepare you for my exam. I just want you, kasi after I give the quiz, I give back the results of your quiz before the midterms. So you can determine as to how to adjust the answers, how to prepare. Kasi I know different professors have different preferences when it comes to answering the exam. And ayoko mapakalo, biglang midterms na, tapos dun pa. And then mababa yung grade just because nahirapan kayo mag-tansya. I have professors before na ang gusto nila sa exam ay superlative answers. And I'm not like that. I just stick with the key paragraph to the ala. Ala na lang, wala na yung sa exams ko. And I wanted to prepare. And since I mentioned before that the topics in week 2 are the favorite ones in the bar, we will have a quiz from week 3 before we enter the week 4. And next meeting is anong araw next meeting? 24? Okay. Next meeting will have kailangan mo kayo mag-quiz na face-to-face. Okay. Here's your, kailan ang exam mo? Tapos 21 pa? So, ibig sabihin, aabutin natin yung week 6 hanggang week 6. Grabe tayo yung topic natin sa hanggang week 6. Hanggang board. Okay. So, hanggang board. Next meeting kasi, I prefer to have an online class. So, the quiz will be August na. Kaya lang kasi mag-iitin tayo. May 31 pa yung July. So, we really have to take a quiz for next week. Para may time ako mag-check and then magbalik. Sige. Next meeting will meet face-to-face. Huwag sana kumulan. Class! Huwag sana kumulan. Walang mag-rate dance. Rate dance yun. Walang mag-rate dance. Kailangan natin pumasok sa Friday. Kasi, kapag pinag-online exam ko kayo, kaya hindi ko rin ni ChatGPT yung sagot eh. Tapos yung papasa sa akin galing ni ChatGPT. Paano kayo sa midterms?
Wala naman yung other teacher.
Sa midterms, I prefer handwritten answers. I don't require a lengthy answer naman. But I require na handwritten siya just to make sure na walang magagamit na magic. I'm a pandemic baby. I mean, pandemic ako nag-law school. And I know the tricks sa game. I know, class, ano ba? So, hanggang 4th year. And ang their notes or the AI and all. So, nung sila na lang yung nag-debate, nahirapan na sila. Kasi, ang goal ko talaga class is to train you to answer the bar as early as now. So, let's try to do it together nang walang dayaan na nagaganap. I'll try to make the question so direct that you can particularly answer ng sobrang ikli as much as possible. I just want answer legal basis. Jurisprudence, pag di nyo naalala ka, huwag na kayo mag-invento. Kasi halimbawa yung case, Aboitiz versus Chongban. So so sobrang galing mo, di ba? Naalala ko may Aboitiz tsaka may Chongban dun sa case na yun. Ang problema, baliktad. Chongban versus Aboitiz. Mahirap yun kasi what if sa CE yun pala yung pangalan nila? Ang tinatanong, ang iko-quote natin, of course, the Supreme Court ruling. Kasi di ba, balik-baliktad ang ruling, kaya nga nakakating ng Supreme Court eh. What if nabaliktad sa CA, tapos bumaliktad sa SC? So, iba na yung legal case. Ang sinay mo, yung CA version. Ang tamang jurisprudence, yung SC version. So, mali ka ng sinay. Mali yung jurisprudence mo. Mamabawasan lalo yung score mo. In my class, if hindi mo talaga alam yung sagot, ay hindi mo alam yung case, just say jurisprudence provides that. I will accept that. Alam mo namang tao lang kayo, working tayo lahat dito. Mahirap magkamisado, that's okay with me. But, I'll be impressed, of course. Kapag alam mo yung case, hindi ko pa ako mag-check. Grabe, galing niya. Tapos, wow, amazing. Tapos, check sa ulit. Grabe. Tapos, pag-check ko, mali.